All right, we're going to get started. So I'm Brian Nider, CEO of AbilityPath in Camp Via West. Good afternoon and welcome to AbilityPath Special Needs Trust and Legacy Homes Seminar. Thank you for joining us today for what I believe is going to be an incredibly valuable and informative session for you. Whether you're here as a parent, caregiver, family member, or advocate for someone with a developmental disability, you've taken an important first step in prioritizing long-term planning. At AbilityPath, we recognize that planning for the future when you have a loved one with a disability can be overwhelming. It's a complex system. Questions about housing, financial security, benefit preservation, and ensuring your loved one's care continues long after you're gone. These are just some of the important concerns that you may have. They are deeply personal matters that keep many folks awake at night. That's exactly why we put together an outstanding panel of experts for you to hear from today. Our goal is straightforward: to equip you with the knowledge, resources, and confidence you need to create a comprehensive plan that safeguards your loved one's future while maintaining their access to essential benefits. In the next hour and a half, we're going to explore critical areas such as the foundation of effective lifespan planning, estate planning, conservatorship, financial planning, and access to benefits. Our distinguished speakers will share practical insights, answer your questions, and help demystify what can feel like a complex legal and financial system. This is your opportunity to learn from leaders in the field. Ask the questions that matter most to you. We do have cards and pens for you to fill out questions that we'll take and put them together at the end of the session, which we'll share. Most importantly, though, this is a safe space where your concerns are understood and your family's unique needs are respected. Please engage with our speakers. Like I said, take notes and prepare your questions for the Q&A session. Know that you are not alone in this journey. Together, we can ensure your loved one has the security and support they need to thrive, not just today, but for the years to come. So with that, let me introduce you to today's panelists. First is Lev Mass, founder of Cradle 2. Lev, go ahead and stand up. Lev specializes in innovative financial planning and legacy giving solutions for families and nonprofits. As founder of Cradle 2, he helps families create affordable legacy insurance policies that can transform modest monthly contributions into substantial future donations, some of it for housing. With 20 years of experience in technology and venture capital, he also holds an MBA from Columbia Business School and a dual degree from UC Berkeley Haas School of Business. Welcome, Lev. We can give him a round of applause. There we go. Lev is going to share his unique perspective on innovative financial strategies and long-term wealth planning for families with special needs. Next are the dynamic duo of Mark and Mike Gilfix. Mark is an award-winning estate planning attorney who specializes in special needs planning, elder law, and multi-generational tax planning. A Stanford graduate, go card, and sought-after speaker, Mark has helped thousands of families navigate complex estate planning decisions. He brings expertise in trust formation, disability planning, as well as creating comprehensive legal strategies to protect families while preserving access to government benefits. Mike Gilfix. Mike is a nationally recognized pioneer in special needs planning who literally created the first special needs trusts in the early 1980s when he was in high school. All right. As a California super lawyer and member of the National Academy of Elder Law Attorneys, Council of Advanced Practitioners, he brings unparalleled expertise in Medi-Cal planning, asset preservation, conservatorships, and his firm has been serving families with disabilities for over 40 years. Next is Jim Hayek. Jim is a leading expert in public benefits and disability services with over 30 years' experience. As a former executive director of the Alta California Regional Center, he managed over $175 million budget serving thousands of individuals with disabilities. Jim specializes in navigating regional center services, SSI, SSDI, Medi-Cal, IHSS, and special education systems. He works directly with families and attorneys to maximize access to public benefits while coordinating with special needs trusts. Jim, welcome. With that, I am going to turn it, thank you. Yeah, big round of applause for our panelists. The other thing I want to mention is this is the first kind of overview session of 3 more sessions that we'll hold. The plan is over the coming year, we'll have sessions that go deep on 3 different topics. And so be on the lookout for messages about when we put those together. You know, this is kind of an overview and a primer for the whole lifespan of planning, from the trust, conservatorship, estate planning, to give you a sense of that. But in the coming year, we'll be doing deeper dives in each one of 3 different topics, so you can go into a lot more detail and understand the nuances of that. So with that, Mark and Mike, please welcome to the podium.
Don, you're gonna start.
Thank you. So as we get started, I have just a quick question for you guys, and I would just say, raise your hand if you feel stressed about the state of the world today. Yeah, we live in crazy times. I think you can say that most of the time, but especially now. There's so much uncertainty and so much fear out there. And I think that's compounded if you have a family member with special needs. I mean, that's stressful in the best of times. And right now, we have no idea what's happening at the federal level, which will trickle down to the state level, which will trickle down to the local level. Everything feels like it's up in the air. We have this wave of AI coming that's going to affect everybody. So I think I would imagine many of these questions probably resonate. Do you feel concerned about your child? Does this keep you up at night? You know, do you have sleepless nights where you're trying to fall asleep and then all of a sudden all these worries come back in? Do you just feel overwhelmed? Yeah. Yes, right? I think we all do in different areas of our lives. And I think we hear this, all the time from our clients. I'm afraid to die. And I think everybody's sort of afraid of death, but we don't mean this in our own sense. We mean this in the sense of taking care of our loved ones. When there's someone who relies on you, there's that fear of, if I'm not there, who's going to be there? What's going to be there to support my son, my brother, my sister, my niece, my grandchild? So that's what this is all about. It's about finding ways to build that safety net, to take the steps that you can to protect your loved ones. And if there's just 2 messages we really want to leave you with here, it's 1, hope is not a strategy. Hope that everything will just work out. That's from my manager. I was a management consultant before I was an attorney. Hope that everything's going to work out is not a strategy. You need a strategy, but it doesn't have to be as complicated as you might think. And control what you can control. There is so much, especially these days, that we cannot control. We can't control the congressional budget negotiations. We can't control the macroeconomic conditions. We can't control global warming. There's so much we can't control, but there's a lot more that we can control than we likely think. So we're going to go over just some of the key pieces of the estate plan that you need to have in place and the key decisions you have to make sure you've done what you can, controlling what you can control. I'll just spend 1 moment. I love this. This is serenity prayer. Something got me through some tough times, my wife through some tough times. God grant me the serenity to accept the things I cannot change, the courage to change the things I can, and the wisdom to know the difference. So whether you're religious or not, I think that's a really good message. It's kind of touches on stoicism and all sorts of good philosophies. So that's what I want to leave you guys to leave this talk with. There's areas we can control. We're going to talk about what those are. And thank you, AbilityPath, for having us here today. We're overjoyed to be here, and thank you for giving us the opportunity to connect with this amazing community. Mike, why don't you go over our topics here today? We'll keep it very efficient.
Yeah. And by the way, special welcome to everybody, and thanks to Brian and to Larry. Haven't seen Larry in a while. One of the reasons we do these things together, by the way, is we bring 2 perspectives, 2 generations. So it doesn't, one of us could do this alone, but especially when questions come up, there are different perspectives when you're of different generations. So, we like to listen to each other. We don't have a script. We never know what we're going to say, but we think that's, huh?
The microphone will keep us from talking over each
other. Oh, that's right. Usually we talk over each other. So in terms of what we're going to do, certainly we're going to focus on special needs trusts. What are they? How do they operate? The hidden issue that you need to know about, and hardly anybody does, is property tax. What's happening in the world of property tax? That's this new Proposition 19. It's a nightmare, and especially for special needs families. Again, we'll walk through that with some numbers. We'll talk briefly about the ABLE Act. We could, and maybe in follow-up sessions, we'll get into the interplay of so many tax issues that you just have to think about as you do special needs planning. So you don't just do a special needs trust with special needs planning. Everything has to be coordinated and integrated, the point that we'll make often.
Yeah.
So next,
And this is for educational purposes only. We're lawyers, so we have to say that. And just want to talk about your background.
Yeah. So very quickly, Brian mentioned that we've been doing this, I guess I've been doing this a very long time. It was in 1976 that I created the first free legal services program for folks with disabilities, 1976. Goes back just a while. So we've watched the evolution of these government programs. So we're not jumping in to see, oh, gee, what's going on? In some cases, we've guided the evolution of the law. We've testified in Congress and so on and so forth. So, obviously it's a lifelong commitment on our part, and I'm prouder than you can imagine that Mark has kind of picked this up and he's taking it to higher levels. So this is our firm. We've been around a very long time. Special needs is our favorite area of focus. We do all kinds of planning, but this is, you might say, where our heart is. We have a book on special needs planning. Some of you have it.
We have handouts for everybody.
Oh, yeah, we do have some. If you didn't get them, by the way, there are some handouts, some summaries of key points about trusts. If you didn't get them, pick them up, at the end, or maybe they'll be circulated. We were going to bring some. We forgot, frankly. Anybody who maybe comes to see us, we'll just give you a copy. We do sell them, but for you guys, when we see you, no charges at all. So we have a lot to cover quickly. We will be efficient.
Yes.
Go for it.
So again, I think everyone can relate to this idea that there's a life-changing moment when there's a diagnosis or some issue is going to be around for a while, something you're going to have to deal with for the rest of your life. And so we're going to hammer this point, but a special needs trust is the most powerful document that you can create for someone with special needs. It is, from a legal perspective, and I think a financial perspective, is the tool. And it doesn't matter if you have a lot of money or little money, regardless, you need to have this in place. So let's go over what a special needs trust is and how it fits into an estate plan, because it's not just a special needs trust. You can't just create a special needs trust and say, oh, I'm done. You have to have your own plan, and it all has to link together. So we're going to provide an overview of what that is and how it works together. And again, we think it's one of the most important documents you will ever sign in your entire lifetime. And it's a way to provide a lifelong legal and financial safety net for your loved one. So what really is a special needs trust? At a high level, it's an irrevocable trust, and it's basically designed to hold assets for the benefit of someone with special needs where they don't own those assets. The trust does. And because of that, the trust doesn't interfere with public benefits eligibility. So there's a lot of public benefits programs, and the rules change every year, where if you have too many assets, you aren't eligible. And so that leaves us in a conundrum. You want to support your child, but you don't want them to lose public benefits. Well, a special needs trust is the tool to solve that. A special needs trust could hold $50, it could hold $50 million. It doesn't matter how much, as long as it's managed properly, the assets in the trust don't count as belonging to your loved one for purposes of public benefits eligibility. They are irrevocable, meaning they can't really be changed, but there is flexibility you can build in, and there has to be a third party in charge of it. Your child or your loved one cannot be in charge of their own special needs trust. We'll talk about why that's a really challenging but important choice. Who is going to be in charge of this for your loved one after you're gone? Mike, why don't we talk briefly about first party versus third party trusts?
What a tag team up here, huh? First party and third party trust. There's basically two kinds of special needs. Well, there's many variations, but fundamentally two types. The third party trust is the trust that you create for the benefit of your child or a grandchild or a niece or a nephew, anybody. The idea being that some third party's money is going to go into that trust. That trust says, among many, many other things, that upon the passing of your child, any money remaining goes to beneficiaries, individuals, or nonprofit organizations of your choice. There's no payback to the state of California. The first party trust is very different. That's a trust funded by money held and owned by the individual with the disability. It often comes into play when somebody is injured in an accident or they inherit money and the person leaving the money didn't know any better. and it's going to mess up benefits, or they just can't manage the money. So they can create their own trust. A parent, a grandparent can do it, not hard to create. The radical difference between the two is that upon the death of the beneficiary with the first party trust, there is a payback provision to the state of California for Medi-Cal benefits paid. It's a little more complicated than that, but in essence, there's a payback responsibility with the first party, not with the third party. And not to get into it, but you can imagine that there's a lot of lessons there about which money do you use first if there's two such trusts in existence, which is not uncommon at all. And some of you have probably experienced that. So first party, third party. Mark's made the point already, and we'll repeat and repeat. The trust isn't sitting there in isolation. It's part of a comprehensive plan. So again, you never just do the special need trust. Your irrevocable trust needs to feed into that trust. It needs to coordinate. Maybe there's some tax planning that has to be done. Your power of attorney, your advance directive. All of these documents are coordinated, nothing done in isolation. So, that's easy to say, and maybe some of you have a sense of what that really means, but these things have to coordinate and they have to talk to each other so that your child can be perfectly taken care of going forward.
Yeah. So as Mike mentioned, it's not your estate plan. There's 3 documents you need: revocable living trust, durable power of attorney, advance directive. A trust is a much better version of a will. It makes sure your assets aren't stuck in the courts after you're gone. They stay privately within your family. But that directs where your assets go after you pass away. And very importantly, you don't want to leave money directly to your child. You leave it to their special needs trust instead. Just briefly, power of attorney for finance, also a really important document. If you're incapacitated, it allows you to name the people who can step in and manage your day-to-day business of life issues. If you don't have that, that can cause major issues. And that also needs to incorporate special needs planning. Like, let's say you have a child who's over 18 and you're supporting them. If you're incapacitated, you need your durable power of attorney document to address the fact that it's okay for your funds to support your child. Because once they're over 18, they're not your dependent. So I bring that up just to say that the trust, the power of attorney, all these documents need to link together as part of a special needs plan. Advance directive, healthcare decision-making if you're in the hospital, who can speak for you. So in this very simple illustration, mom and dad, they want to benefit their daughter, Sarah. Very importantly, they don't want to leave money directly to Sarah. They create that special needs trust for her. They leave money to the trust, not to Sarah. That way, her public benefits eligibility remains in place and those assets are protected for her. So again, they're lifelong financial safety nets. You can retain public benefits eligibility, SSI, Medi-Cal. We're going to probably go over that in one of the in Jim's talk. Special needs trusts can also hold property. So we're just touching the surface here, but special needs trusts can hold all types of assets. They can hold stocks, bonds, cash, real estate, rental properties, a primary residence. There are very few limitations on what they can hold. So they're powerful tools, they're flexible, and it's just really important to make sure that your estate plan is coordinated. We're not going to talk too much about this, but it's also important if there's other relatives who might want to leave money for the benefit of your loved one, that they know about this. So their estate plans direct to the special needs trust as well, because sometimes a well-meaning grandparent will leave money directly to a grandchild, not knowing, hey, there's a special needs trust in place. And then you have to go to court and fix it, or you have to take a bunch of challenging steps to overcome those problems. So coordinating, communicating is just so important. So what can a special needs trust pay for? What is it allowed to use?
The general statement is it can be used for darn near anything. We see so few limitations. There's a lot of misinformation and misunderstanding about this. It can impact SSI, which you have the nation's expert on SSI and government benefits with Jim coming up. The experience there is just off the charts, I have to say. So you're in for a treat, and save your questions up for all of us. But generally speaking, anything, education, healthcare, creative uses, you never know what somebody might best enjoy. A lot of special drafting in these trusts identifies what is special about what does your child enjoy most. One of my favorite, this kid was going to get the best updates about skateboards anywhere in the world. And it was mandated in the special needs trust that every year updates, no matter where, they had to scour the country. Important to that kid. It's a great illustration of how these trusts and powers of attorney and advance directives are not check the box forms. They've really got to be individualized, knowing what's going on with your child. Different disabilities generate different issues. I mean, sort of obviously, but it's not obvious. It really isn't. So sometimes provisions will take you in this direction, that. But how challenging can distributions be, and what are some opportunities, Mark? Let's look at one more.
Yes. Yeah. So again, very flexible. That's how these trusts can be used to pay for all sorts of quality of life issues. And you may be thinking, well, that's nice, but can they pay for Britney Spears concert tickets? No, none of you are thinking that, I know. But I only bring that up because there's an actual court case that said special needs trusts can pay for Britney Spears concert tickets. So the point is, whatever your child's favorite artist, whether it's Taylor Swift or Coldplay just played Palo Alto, I know, the special needs trust can pay for that. And it's okay. There are issues you have to be aware of as they relate to public benefits. But just because the special needs trust pays for a lot of these things, if it's managed right, it should not cause major problems with public benefits. So it's about quality of life, making sure they're safe. But if there's enough there, you should give them a great life. So it's not just about the very basics. The most important decision when you're setting up a special needs trust is the choice of trustee. Who's going to oversee this for your child?
You might have gone through the agony. Many of us have individuals in the family or trusted friends where it's a no-brainer. We know who the trustee is going to be. But this question, I mean, sometimes a 1.5-hour consultation, 45 minutes of it is who's going to be the trustee? Who's going to have responsibility? It is tough. And this is not a question of who do you love the most. This is the question of who's going to be responsible, who's going to accept this responsibility. And I think you have to reevaluate this year after year. It isn't static. Lives change. The person you might have chosen may have been perfect 5 years ago, but are they today? So we strongly urge you to constantly think about this and realize that, again, the perfect person yesterday might not be the perfect person tomorrow. So how do we go about this? I always think of it as a bullseye. The bullseye, the target. The bullseye would be the close family member who has time on her hands, who's a CPA, who's utterly devoted to your child with the disability, has nothing else going on in her life. There's your ideal family member trustee. You don't find that person real often. So you get real, you look at family members, sometimes it's closest, not your new friend that you just met at the supermarket who seems cool, not that person. You really got to have a high level of confidence because they have your child's life in their hands. If you don't find somebody within that circle, that bullseye of family and very, very close friends, you go to the world of professionals. There are individual fiduciaries, individuals who are in the business of being trustees. It's a big business. There's many, many people in it. Some are capable, some are not. I don't think the bar is extremely high to pass the exam. It's not a criticism generally, but you just have to be very careful when you make your choices. Ideally, you have to pick somebody younger, not somebody who's in his 60s or 70s, like this guy happens to be. Not a good choice. It's got to be somebody who's going to be around. Some go to financial institutions, and there are some nonprofits that accept this responsibility. Does AbilityPath service trustee? Not yet. It's a challenge, but it's also an opportunity. So it is a tough thing. So many people have nobody, and it doesn't feel great to give it to a bank or to a professional. But you got to work it through. You got to be realistic about this. So it's one of the things we talk about in great depth. We can help out with that. It's tough.
Yeah, and just to revisit, I know we're going fairly quickly here, but there's 3 other documents that you need beyond the special needs trust. Just to revisit this, because I think it's really important that we all know this. And everyone over the age of 18 should have these, by the way. Revocable living trust, also known as a living trust, also known as a revocable trust, making sure that if you're married, you have the right structure, but you need that. If you did one a while ago, you can always revisit these. You should make sure they're up to date. So that's what directs where your assets go, keeps them out of the courts. Powers of attorney for finance, durable power of attorney. So if you're incapacitated, you've empowered people you trust to deal with your day-to-day business of life issues, making sure they can support your loved one with special needs in your shoes if you're still living. Advanced healthcare directives. So we can help with all of this. And even if you did a plan a while ago, it's a good idea to revisit these every 3 to 5 years. Make sure the right people are named, the right structures in place, laws change. So critical to have these. And we can help, of course, to revisit a plan if you did one a while ago. And if you don't have one, you need to set it up. So now let's transition. We want to be cognizant of our time here, but this is a really important issue, and this is the savage impact of Prop 19. If you own a house in California, and if you're fortunate enough to have a rental property, and if you want to keep these available for your loved one, you need to understand this new law and what you can do to plan for it. So walk us through just the high level of this law.
When Prop 19 was advertised, it mentioned a couple of nice things, good things. It didn't mention this particular impact, and this is the core and the heart of Prop 19. It's what it does to your property and property taxes upon your passing. So let's do a quick overview of what it says. Before Prop 19 passed a couple of years ago, you could pass along your home to your child, whether or not they lived in it, and there'd be no property tax increase. And another $1 million in assessed value. You might have bought a place at Tahoe a long time ago. It's worth $4 million, but the assessed value was $400,000 because that could have been passed along to your child with no property tax increase. So Prop 19 wipes all of that out, all of it. We have to look first at the residents. There's one approach, and then everything else. With the residents, there's a partial break. In other words, let me back up a little. So the idea is, upon your passing, the county looks at the value of your home, and the assessed value will reflect the market value, not what you paid, but the market value, which means property taxes will skyrocket. Mark's going to go through a couple of illustrations in a couple of minutes. So with the residents, in other words, if it's your residence, the home you live in, and if your child becomes the resident of your home, only then there is a partial break. In that event, the first $1 million in assessed value is forgiven. So if it's a $4 million house, the new assessed value would be $3 million. Still a massive property tax increase. In Wairika and areas with lower property values, if it's the residents, that could wipe out the property tax increase, but not around here. What if it's not the residents? What if it's that duplex or that little house that you set aside for your child? That's going to be your child's future. You own it. It's going to go to the special needs trust upon your passing. It's nailed. There's no protection. There will be a reassessment. So let's say it's a $3 million property. Property taxes will go to about $33,000 a year. Maybe they're now 5 or 8 or 10,000. And that's every year. And then it goes up 2% a year. This is hundreds of thousands of dollars for a small property. If it's a valuable home that you want to keep for your child, the numbers are absolutely staggering. So you have to be aware of this. Don't have your head in the sand. I was actually telling Brian about somebody who called up recently, a special needs family. Mom died. They didn't know about Prop 19, and they just got a gigantic new bill for property taxes. It's so big that they're not going to be able to keep the house. They don't have enough money in the special needs trust to take care of the property taxes, and it's too late. So it's a massive problem that we think about all the time, and we do have solutions. We'll talk about that if we have time.
Yeah. So Mike mentioned if you haven't planned ahead while mom and dad are still living, it's too late. Once someone passes away, it goes to the kids. There's really nothing we can do to keep taxes where they are. So this applies to you. If you've owned a property for more than 10 or 15 years, you need to pay attention. Let me just show some numbers. I'm an Excel nerd from my management consulting days. So a $3.3 million home, I know it's a big number, but in Palo Alto, that's like a small house these days. It's crazy. But let's say mom and dad bought the house decades ago. The assessed value for property taxes is $300,000. So they're only paying $3,600 a year or so in property taxes. If your child lives in the home, even if they move in, we are talking about a $22,000 a year increase in property taxes, even if the child moves into mom and dad's home within a year of their passing with the limited protections. And the numbers are staggering in the sense that over 5 years, that's $115,000. Over 30 years, that's almost $900,000 in extra taxes. And if there's someone with special needs, just think about how that money could be better put to use. What if it's invested in earning 7% a year rather than losing $25,000 a year on average? If your child's not living in the house, or if it was not your residence and you want to keep it for your child, the numbers are even bigger. We're talking about over $1.3 million in extra property taxes over the life of your child after you're gone. So if you look at the numbers and what that could have done for your child if it was invested, that might that could be a $3 or $4 million difference. That can be a lifetime of support for your child if you want to hold on to these properties. So without going into more details, our firm has developed solutions for this. It takes time. Francis Lopol, our tax attorney, has several approaches he uses. It depends on the situation. There's no one size fits all solution. But if you want to keep a property for your child with special needs, maybe it's a rental to support them, you need to plan ahead. And there are ways to do it to keep property taxes low, to still get a stepped up cost basis when you pass away, which is also really important. And it can work whether it's a grandparent to grandchild, uncle to nephew, but we can plan ahead, but it takes time. It takes 12 to 24 months to do. There are risks involved. You have to make sure insurance is good. There's always, the county is starting to look more closely at strategies that different attorneys are using. There's a step transaction risks and things like that. We're very cognizant of these. We've had no issues so far, but there are some risks to doing it. But the risk of not doing it is a guaranteed massive increase in property taxes. So we've helped a lot of families with this. Our YouTube channel, Gilfix Law YouTube, our most viewed videos are about this. So check it out. We can absolutely help, or just talk to us if you want to learn more about that. So we have 5 minutes to go. So we can get through the rest. Also, other housing options. Lev is going to talk about some really innovative ways that you can also leave money for the benefit of your child while supporting AbilityPath. So that's going to be another presentation. We're excited to learn more about that. So I want to spend just a little bit of time about the framework of how to think about, is there enough, and what you can do if you don't think there's enough. So, this is just autism, but the cost of supporting someone with special needs is skyrocketing. Public benefits are not growing. If anything, they're shrinking. The population that needs help is growing. So how can you be sure that you have enough? So I think a framework that I like to use when I'm speaking with clients about this is kind of like retirement, the 4% rule, that you can take out 4% of your invested assets every year. It should last the rest of your life. So if you have $1 million invested, you should be able to take $40,000 a year, and that should last the rest of your life, historically at least. Similar to special needs planning. You want that safety net to be there. You don't want it to be going down every year. So you can say, okay, well, how much do I need in a special needs trust so that 4% per year, 3 or 4% is enough to support my child's basic needs or my loved one's basic needs. So you can back that out. If they're going to need $40,000 a year, okay, maybe about $1 million needs to be in the special needs trust. You might think that's great, Mark, but I can't just create $1 million if I don't have it. Depending on your situation, you actually might be able to sort of do this. And we're big fans in this planning context of exploring life insurance, because that can be a way, depending on your age and your health, where you can buy policies that will fill that gap. Somebody want to just give this quick example? We'll make it. So we've had examples. This is just illustrative, where people have been able to get $1 million policies with one-time payments of $60,000. They paid one time $60,000. And it got them a guaranteed $1 million death benefit. This is not a guarantee. This was a while ago. This was a husband and wife insured together. So I'm not saying this is exactly what you can get, but we are big believers, I think most planners in this space are, that life insurance can be a really good tool to fill a gap. Yeah, the cost might vary, but you might only have, there's some policies where you literally make one payment. So the idea of $1 million down the road, that's hard, but maybe you can come up with $50,000 or $60,000 in the next couple of years to pay for that. So that's a great tool to fill that gap. You can also leave retirement accounts to special needs trusts. You can leave life insurance policies, retirement accounts, investments, and obviously you want to invest well. Real estate, keep that in mind. The property tax issue will kill the ability of the trust to hold on to property if you don't plan ahead.
3 more.
I think I'm going to say a couple of words about the ABLE Act, and most of you are familiar with it, and then Mark will kind of wrap things up for us. We want to respect time for Jim and for our two speakers. So ABLE Act, you're probably well aware of it. The question is, should you do it? How does it fit? It complements, it never ever replaces a special needs trust. It has many great uses. I think there's some limitations on its uses.
Debate that $100,000 limit.
Yeah, you could put up to $19,000 a year into that account. Anybody can. It can be the individual himself or herself. And your kid, if able, can manage that money. That's one of the beautiful things about an ABLE Act account. You can have up to $100,000. I rarely recommend that much because upon the death of the individual, the state, by federal law, has a payback responsibility. California,
Sorry.
this guy's harassing me over here. California ignores that federally mandated responsibility. So you might know there's no payback in California, but I would not count on that going forward. It violates federal law. So Mark, I think wrap up and move on to Jim. Yeah.
Yeah, we want to be very cognizant of the time. So we had a couple other things we were talking about. Plan giving is part of your plan. We do want to touch on that because there are amazing ways that you can leave money for the benefit of AbilityPath or other wonderful nonprofits that can be very tax efficient. Charitable remainder trusts. Lev is going to talk about some tools with housing where you can leave money for the benefit of AbilityPath and other organizations while still providing amazing benefits to you and to your child. So we always want to talk about that in the context of special needs planning. Many wonderful tools available. And special needs plan check. I think the main thing, you need to have an estate plan. If you don't, get one into place, and you need to have that special needs trust there for your loved one. And if you have a plan, maybe you did an estate plan a while ago, but you don't have a special needs trust, we can help with that, or you need to add that. You might not need to redo everything. You probably have to make some major updates. Make sure it's in place. And if you do have a full plan with a special needs trust, revisit it. Make sure it still makes sense. We'd be thrilled to help you look through that. It's our privilege to help people review their plans. Our team is not just Mike and I. We have Jeff Mendelman, Francis Lepole, Nick Klingenberg, Joshua Lepole. We have a great team, but I want to get back to hope is not a strategy. Control what you can control. These are high leverage moments, right? So you take just a few days thinking about this, set a meeting to update your plan, spend investing in a good plan. These are high leverage decisions. You make the right decisions now, they can have massive impacts on your loved one's future. And not having the right plan can unfortunately have massively negative impacts on your loved one's future. So we want to avoid that. So we do want to offer, our firm doesn't usually do free meetings. We usually charge for our meetings. We just don't have the capacity to meet with everybody. But if you're here today, grab one of our handouts. And if you want to meet with us, we are happy to offer a 30-minute complimentary meeting just to go over these with you. No commitment. We're happy to go over things. If you want to make it part of a bigger planning meeting with us, the first 30 minutes would be no charge, and there might be some billable time after that. Then we have flat fees. We always let you know how much our fees would be. We haven't raised our costs on a special needs trust for like 20 years. So we really it's our privilege to help you. But either way, whether you work with us or not, take action, get that plan into place, and coordinate your financial plan with that. Look into life insurance. Think about that Prop 19 issue for your house. It's a huge one. And you can find us, gilfix.com. We have little ways to subscribe to our YouTube channel. We have a lot of free videos regularly posted. So I think we'll take questions, obviously, at the end with the panel. But went through a lot there, and I think we're within 1 minute of our time. So thank you very much.
Great. Mark and Mike, thank you very much. Real quickly, we do have pens and paper in the back to write questions. So if you want to grab those, we can certainly pass them around. One thing, this is not meant to be a pitch for AbilityPath, but I am thankful for Mike and Mark mentioning us. This is meant to be information for you as a community. And we're going to make sure all the materials are available to you. We'll be posting the video. We'll get a transcript of today's sessions as well. But again, our goal is to inform you about how to prepare for the future for yourself and for your child. And with that, Jim, stage is all yours.
Thank you, and thank you to AbilityPath for inviting me. A great presentation on special needs trust. Most of the families I work with do have special needs trust, either first or third. It's an invaluable tool. So I totally endorse what they were discussing. Okay, let's get into, I think my PowerPoint's supposed to be here. There it is. Okay, there's my contact information in case you need it. I've got business cards if you'd like at the end. So there's various types of public benefit programs. We're not going to be able to talk about all of them in 30 minutes, but there's what's called needs-based public benefits. And by needs-based, that means financially means tested. SSI, Medi-Cal, IHSS. We'll be talking about a few of those. There's also entitlement programs, Social Security disability insurance, Social Security disability, childhood disability benefits. We'll be talking about that. The Medicare that goes along with that. And then there's other programs, Regional Center, Department of Rehabilitation. We don't have time to get into all of those, but I'm happy to talk to you about Regional Center. I was executive director of a regional center for 10 years, so I help lots of families navigate through those programs. But today we're not talking about regional centers. Okay, we're going to talk about SSI. A lot of you folks may or may not know about supplemental security income. It is not a Social Security program. It's just administered by Social Security. It is a welfare program. It is for people who have very limited income, limited resources, maybe over 65 or disabled. So you must be disabled under, if you're applying for SSI on the basis of disability, you must be disabled under Social Security's definition. I mean, many people have disabilities, but for Social Security, that's just the first step. That disability must result functionally in the individual not being able to work substantially, and that's called substantial gainful activity, or SGA. Social Security operationally defines that in 2025 and this year as the ability to gross $1,620 per month. It's not whether the individual ever had a work history making that much or whether there's a job available in the neighborhood making that much. It's upon reviewing all of the documentation of the applicant's disability, do the Social Security doctors and psychologists determine whether the person's capable of SGA or not. The other requirements are financial. There's a resource test. The person cannot have more than $2,000, and income. They can have some income, and there's different types of income, but it will affect the amount of SSI that the individual receives. So the resource test, again, $2,000 for an individual, $3,000 if it's an eligible couple. Now, not all of the resources are counted. There's some that are exempt. A home of any value, as long as the individual is living in it, automobile of any value, furniture, clothing, personal care items, none of those are counted. Burial plots, certain types of life insurance, whole life insurance is counted because there's a face value to whole life. So if it's in the individual's name, they count that towards the $2,000 resource limit. So you have to be careful of that. Special needs trusts, interestingly enough. And when you're applying for Social Security, when an individual applies for SSI, they will ask, one of the questions on the application is there a trust for the benefit of this individual? And you have to disclose that to Social Security, even if it's not funded. And people say, well, why, if it's not even funded, there's no money in it, do we have to tell Social Security? It's because when you're once on SSI, you may have financial reviews every once in a while. And that's where they will say, you'll get a letter, you're saying, even though you're on SSI now, we want to make sure you're still eligible. So they will want to know that there was a special needs trust in place when you applied, because they're going to ask you about that when they do this financial review. They're going to say, we know you had a special needs trust. Has it been funded yet? Are there distributions being made from it? So you do have to disclose that. Income test. Income reduces the amount of the monthly SSI. So there are different types of income, and you have to forget all about IRS rules as far as income. There's earned income, which is pretty self-explanatory. If an individual has earned income, the Social Security does not count the first $65 of earned income. They also have a $20 exclusion for any kind of income. So you add those two together, 20 and 65, that means the government in its graciousness allows an individual to make $85 a month and not affect the SSI check. Anything over 85, the SSI check goes down 50 cents on the dollar. Now, if there's direct income, someone gives the child a gift and you don't want to do that. You want to put it in a CalAble account or you want to put it in a special needs trust. If the SSI recipient receives cash after that first $20 exclusion, their SSI goes down dollar for dollar. And then there's another kind of income that Social Security looks at, and that's called in-kind income, sometimes referred to as in-kind support and maintenance, ISM. And that is if someone is providing the shelter to the SSI recipient, then their SSI check can be reduced. So in 2025, in the state of California, the maximum benefit that a person on SSI can receive is $1,206.94. Now, it used to be that in-kind support and maintenance was affected by both food and shelter. In other words, if the SSI recipient was getting free food and shelter, then their SSI check would be reduced. They, excuse the pun, but they took food off the table last year and food being provided to the individual no longer reduces the SSI, but shelter does. So if an SSI recipient is getting free shelter, in other words, living in mom and dad's house, not being charged rent, their SSI check goes down by $334. So the way that we avoid that is we get someone on SSI, and then I know it sounds weird, but the parent becomes the landlord, the adult child becomes the tenant. We execute a rental agreement between the two of them, and we have the SSI adult pay the parent, I always say $350 a month, begin paying that out of the SSI that the recipient is now receiving, provide that documentation to Social Security, both the rental agreement and the documentation of it being paid. And then the SSI check will go up to the maximum amount. Okay, how does Social Security treat special needs trusts? Well, you heard some of this already. The direct distributions from a special needs trust to a beneficiary, which should never be done, that would be counted as unearned income, and that would reduce the SSI benefit by dollar for dollar after the first $20. You don't want to have the money going directly to the beneficiary. You saw that big long list of all the things the special needs trust can pay for and can provide. You don't give the money to the beneficiary to buy those things. The special needs trust pays directly for those things. And then there's no effect on the SSI unless it's paying for shelter. Next, there is a deeming. So for those of you who have children who are under 18, you've probably learned if you've tried to apply for SSI, the parent's income and resources are counted until the individual's 18. So I work with lots of families. We're a couple months away from the person turning 18. We wait until the month after the individual turns 18 to apply for SSI. Because interestingly enough, way back when I first started this, we would have people apply for SSI in their birth month. But the problem is Social Security goes back to the first of the month. On the first of the month, the person was still 17. So the parent's income was counted and they got an SSI denial. So we always wait now till the month after the birth month when the person turns 18. Okay, so CalAble, we already touched on that. You can look down very quickly. And if there's any questions on that, I don't want to repeat that. Okay, we're going to move on to IHSS, in-home support services. If a person is on SSI, they automatically get Medi-Cal. It's called SSI-linked Medi-Cal. Now, there's other ways to get Medi-Cal. There's pages and pages of what's called the codes to qualify for Medi-Cal, and that's Medi-Cal that you would get through your local county. But if you're on SSI, you automatically get Medi-Cal. You don't have to apply for it. If you're on Medi-Cal, you qualify to apply for IHSS, in-home support services. It serves children and adults with disabilities who are unable to perform activities of daily living, cannot remain safely in their homes. Again, eligibility, the person must have Medi-Cal. They must live in a home or an abode of their own choosing. They cannot be in a board and care home, can't be in assisted living, can't be in a nursing facility. It has to be in their own home or in their parents' home. So once you apply, the county social worker will come out, do an assessment. Social worker will assess the types of services and the number of hours that the applicant needs for assistance in activities of daily living. The maximum number of hours you can get for IHSS is 283 hours. So what's the process? You contact the IHSS. Each of the counties in California has a little bit different way to apply. Now, the first step is you have to get what's called a healthcare certification form filled out. That's where a doctor, one of your child's or adult child's doctor will say and sign on the dotted line that if this person doesn't get IHSS, they're in danger of being placed outside the home. Now, sometimes doctors get a little queasy about such a strong statement. So we sometimes have to doctor shop a little bit and say, well, does your son or daughter have another doctor that's willing to sign this form? Because if you don't get that healthcare certification form filled out, you don't go to the next step. Next step is that IHSS assessment that's done by the social worker. It used to be that they would look at time for tasks. In other words, they'd say, let's say for a very disabled person who had to be diapered, how many times were they diapered during the day? How long did it take? Were there sheets and bedclothes that had to be washed? And they would time all that out. Well, it got very laborious and it became very inconsistent in terms of the hours that were authorized. So they came up with what's called county guidelines. So they pretty much just look at how disabled the person is, how old they are, and boom, that's how many hours they're going to give you for that particular task. Now, after they've made the determination, of course, like every other agency, they issue you a notice of action. And that notice of action will give you it will indicate how many hours in each of the categories, which I'll go through in a moment, of how many hours and minutes they have authorized. So what are the categories? What types of things can IHSS hours be authorized for? Domestic services, sweeping, vacuuming, taking out the garbage, wheelchair cleaning, battery, what's called related services, meal prep, the cleanup for that meal. And they'll ask specifically, they'll say, well, is there a meal that's prepared separate from the family's meal? If it's the same meal that the family eats, they don't give you any time for that. It's got to be a separate meal. Personal care, such as feeding, bathing, grooming, dressing. Now, the interesting thing about this is it has to be hands-on. So in other words, if Johnny's in the shower and you're standing outside the shower and you say, Johnny, don't forget to wash your hair, they don't give you any time for that. If you have to open the shower door, put the shampoo on Johnny's head and massage it in, they give you time. That's how specific they are. Same with feeding. If you have to literally put the food in Johnny's mouth, you get time for that. If he can feed himself, even with his fingers or whatever, you don't get time for that. They do give some time now for transportation to medical appointments and alternate services like day programs, therapies, things like that. They also give for paramedical services, injections, breathing treatments, catheters, skin and wound care, all of the things you see there. But it's government, so there's another form that has to be filled out. So you have to have a doctor who says that these things are needed by Johnny and that you're qualified to provide them. Because some of these are, giving injections and things and breathing treatments, nebulizers. So that's another form that has to be filled out before they will give you some hours and minutes for paramedical. Now, the jackpot is what's called protective supervision. That is a category of IHSS hours that are for people who, due to their mental impairment or mental illness, need to be observed 24 hours a day to protect themselves from injuries, hazards, or accidents. And they literally look at three categories: memory, orientation, and judgment. So how does the person's disability in those three areas put them in danger of harming themselves? And guess what? Another form to be filled out by the doctors, a protective supervision form. And literally there's a line for each of these: memory, orientation, and judgment. And there needs to be an anecdotal example of, well, Johnny runs outside. Johnny gets into the chemicals under the sink. Johnny gets into the knives in the kitchen. Johnny, has ingested things that he should be ingesting. The doctor's not going to take the time to fill out that form. So I always say to my families, fill out that part of the form yourself and give it to the nurse or whatever. So the nurse takes it to the doctor and the doctor signs it. But you do need to have anecdotal examples or they're not going to approve protective supervision. And the thing about protective supervision is that you automatically get the maximum hours of 283. Okay, so that's the maximum hours if you get protective supervision. Now, who can be an IHSS provider? It used to be that if in a two-parent household, one of the parents had to be working, the other parent had to be precluded from full-time employment to stay home to care for Johnny before the parent could be paid as the IHSS provider. They've changed that now. They got a lot of static, I guess, about it, so they changed that regulation. So that's no longer a requirement in order for the parents to be paid as the IHSS provider. Okay, moving right along. This is like speed presenting. Okay, another benefit that I work with a lot of families on. Well, let me back up. I think everyone has heard about Social Security disability insurance. If you work and you pay into the Social Security system and then you become too disabled to work, you get a benefit called Social Security disability insurance. But there's another benefit that your disabled family member, child, can apply for off of your Social Security account. And it's got this big long name, Social Security, Disability Insurance, Childhood Disability Benefits. Now, it used to be called Disabled Adult Child. And so you'll hear lots of the folks still refer to it as Disabled Adult Child versus Childhood Disability Benefits. Don't be confused. It's the same benefit. People are using the old terminology. This is a benefit that pays adults whose disabilities began before the age of 22. And it's currently, well, I went through what it's currently called, but it is a benefit that the individual pulls off of the parent's Social Security account if the parent, one of the parents, is on Social Security retirement or Social Security disability. Now, it does not negatively affect the amount that the parent is receiving, but the child's benefit is based upon what the parent is receiving. While the parent is alive, the adult child will get 50%, will get a benefit based upon 50% of what the parent is getting in Social Security retirement or disability. And when the parent passes away, it goes to 75%. So this is, again, sort of a long-term planning. I have some families that I began to work with, and the parents are like 64, 65 or whatever. And they say, oh, both parents say, we're going to wait till we're 70 to get Social Security because we'll get a bigger check. And then we start talking about the medical insurance that the child currently has and the medical insurance the child's going to need in the future. Because once the child is on this benefit, SSDI-CDB, for 24 months, they get Medicare. And so many of the families finally realize that one of the parents better go on Social Security at 62, get that 24-month clock started because Johnny is currently being covered by one of the parent's employer's insurance. And of course, when the parent leaves that employment, Johnny loses his health insurance. So I have many families that all of a sudden, they say, well, one of us better go on Social Security retirement so we get that 24-month clock started. Doing okay? Again, parent must have paid in. Parent must be receiving either retirement or Social Security. We covered that. Now, what is the effect of work on these two benefits that we've been talking about, SSI, SSDI, CDB? First of all earnings must be reported to Social Security. And let's back up a little bit. When a person applies for either SSI or SSDI, CDB, Social Security is going to make a determination as to whether that individual can handle the responsibilities of being their own payee. And the responsibilities of being their own payee is not just receiving the money and spending it. It is reporting. The reporting that needs to be done if the person changes address, if the person's trust is funded, if there's a change in their living arrangement. Those are things that need to be reported. And so for some of our consumers, they're not capable of doing that. Social Security, in its sole discretion, will decide whether that person needs a rep payee. If they need a rep payee, it's usually a parent. That parent then takes on the responsibility of reporting all of those things, including wages. And that means that if your son or daughter is working, is on SSI or SSDI CDB and is earning money, you need to turn in those pay stubs every month. I've had situations where those pay stubs are not turned in. And what happens is the IRS and Social Security have their computers linked. So when your child, maybe he's not making a whole lot of money, but files a W-2, IRS learns, or 1099 or whatever it is, IRS learns about, Social Security learns about that earnings because the computers are linked. You'll get a letter saying, it's called an IRS flag. Social Security will send a letter to the recipient, to the applicant, to the beneficiary saying, we've been informed that you made some income that you didn't tell us about. You need to tell us about that income. And it could go back 2 years. And then Social Security is going to say, we need to know not just how much you made in the whole year, because that's all IRS knows as you turn in your annual earnings. They will want to know how much you made in every single month, because as I said before, the amount that you earn month to month to month can affect your SSI. So you're going to have to give them a breakdown of, if it was $5,000 Johnny made, or, 2 years ago over a 12-month period, they're going to want to know specifically how much that $5,000 was earned in each of those months. Social Security will then go back and adjust and make a determination that the SSI check that Johnny received in those months was an overpayment, and he'll have to pay it back. SSI overpayments, SSDI overpayments are the same. You have to pay them back. There's no interest, penalties, or fees. The way they usually get paid back is by reducing the benefits moving forward, usually by 10%. So that's the way that you pay back any type of overpayment. Now, SSDI is a little bit different. If there's earnings under SSDI, the benefit amount does not go down, but it triggers what's called a trial work period, where they will look, your benefits will continue up to 9 months in a 5-year window. So Johnny may work 2 months here, may work 3 months a year from now, 5 months, 3 years from now, but they'll give him an opportunity to work 9 months in a rolling 5-year window and not reduce his benefits. And they will look to see if earnings are over $1,160 or more. And for each of those months, it'll be counted as a trial work period. Now, I've had some, Social Security is understaffed. There were just 7,000 positions, as you've probably heard, eliminated from Social Security. Even before that, some of the families would get a letter saying, we were just informed about the earnings that Johnny got, 2 years ago. And we have determined that he's exhausted his 9 months of trial work period. And we Social Security continued to give him a check. You owe us back that money. It doesn't matter that Social Security shouldn't have paid him, because remember, you were supposed to report that income. And if you didn't report it, then they continued to give him checks. So you got to be really careful. So you don't want to exhaust those 9 months of a trial work period and not know you've done it, because if those checks keep coming, you're going to have to pay them back. After that, there is what's called extended period of eligibility for 36 months. That is where the person continues to receive benefits until they achieve substantial gainful activity of 1620. So they give you a little bit of time. And also the Medicare that's affiliated with the SSDI can go on for up to about 84 months. So they do give you a little bit of leeway on that. There it is. Okay, now there's some individuals you can imagine who are on SSI when the parents are younger, but then when the parents get older and go on Social Security, we want to transfer the benefit off of SSI onto SSDI CDB. So for one reason is it's probably going to be a higher benefit amount. And also SSDI CDB is not affected by any income except earned income. So if Johnny's on SSDI CDB and grandma and grandpa give him $50 or $100, that's not going to have to be reported like it is on SSI and result in a reduction. So we want to get the child off of SSI over to SSDI CDB. But there's a couple of tricks on this. One is that the individual has to have been disabled prior to the age of 22. Now, if they went on SSI at age 21, we've got the proof. Social Security said he was disabled at 21. But where we find the biggest problem is the individual cannot have worked substantially since they were 22. So if Johnny has gone out and done even a couple of jobs where he can show that maybe he can achieve substantial gainful activity, he will not be able to apply for this benefit, which is a really important benefit. So, I mean, it's such a disincentive for Johnny to try to work, because if he tries to work after the age of 22 and shows that he can work, he's never going to be eligible for this benefit. That's it. I think I made it. Okay, we're going to have 2 minutes to spare.
Holy. Did anybody see the movie Beautiful Mind? How about the emoji with the eyes that go in opposite circles? Jim, I don't know how you keep track of all that. That is unbelievable. The complexity that families have to go through. And you couple that with special needs trust and all the planning around that. It's tragic to see the system that we have out there in so many levels is very, very hard to navigate. And you put in accessibility issues, language issues, and things like that, it is daunting. So I've got a question before Love comes up. And the first is, we are going to have 3 more sessions, like I said. We would do on special needs trust, we do one on Jim's benefits, and then we do one on housing. And just listening to this, it's hard to cover it, even if we go into more depth in single sessions, in an hour to hour and a half. And just by a show of hands, if we had a longer work session where you could actually have some examples of what families need to consider, would that be helpful to people? Would you show up? Just raise your hand if it's something you'd attend. Thank you. So we'll be thinking about that as we plan going forward. We're going to go around. If you have a minute to write any questions you might have, we want to make sure we're going to have 30 minutes for Q&A. So if you've got some questions that we can answer for you, please fill those out. And with that, Lev, do you want to come on up? And we're going to talk about the lifetime planning, insurance, and how it can help with benefits after you pass. Thank you.
Thank you, Brian. Hello, everyone. And Jim, wow, that was a mouthful. Anyway, so I think everyone's here because they have a special needs loved one. I do as well. And after being executive at Yahoo for many years and a few other places, was trying to figure out how do we have a huge wait list. Housing is really the issue of our time for special needs. How do we help these individuals, and how do we ensure? I think the number one concern for any family is who's going to take care of my child when I'm gone, as everyone said. And the main thing is, where are they going to live? So our team, which is a number of dads from various backgrounds, came together to really figure out, is there a better way to create housing? And I've heard a variety of different numbers of the wait list in California for special needs housing. How do we create more housing? So anyway, one of our, so Cradle 2, as it was originally existed, was a funding mechanism, is a funding mechanism for special needs housing. And one of the ways that you can create a future group home is by donating a house, either a primary residence or a house that you have for your special needs loved one, to a nonprofit. And one of those nonprofits could be AbilityPath. And so like I said, the main challenge right now is that 85% of special needs individuals live at home. And so there's about 15 million special needs and mental health individuals in the US. So that's a lot of people. And, and there's at least a 5 to 7 year wait list to get housing, and, unless you're on some of these housing assistance programs, it's a huge financial burden to families. So what we came up with and especially with Prop 19, which the GILFIX has discussed, it's a huge, huge issue. And so how do you ensure that your loved one will be taken care of in the future? And one of the ways is this donation and leaseback model, which avoids the Prop 19 step-up basis. So there's, if you have a home that you'd be willing to donate to a nonprofit, there's actually a lot of benefits to the family. And one of which is this donation and leaseback model, where you can basically donate your home to a nonprofit in the special needs space, continue to live there through basically leasing it back from the nonprofit. And also what this does is you get a tax deduction on the value of your home while you're alive. And also because the nonprofit has a property tax exemption in the state of California, you will not pay property taxes on that house. So this is, and when the primary caregiver for that special needs loved one passes away, then it transfers to that nonprofit along with the primary resident. And many of these nonprofits will turn it into a future group home with your, with your specification on the people that are able to co-house or cohabitate with your special needs loved one. So I think where we come in, we help with this process in many ways, and we work with your special needs attorney. All of you should have a special needs trust, as we've learned. The main thing as well is, how do you fund the maintenance for doting house? Because one of the things that most people don't think about with the home donation process to turn into a future group home is, because these homes are not usually sold, is the maintenance. And so we fund the maintenance through life insurance typically. And as Mark and Mike Gilfix mentioned, especially doing it while you're younger, you can do it, as he said, one time for about 10 to 20% of the value of the maintenance. So, the house, usually the nonprofit will come up with a pro forma of what it will cost to maintain that house in the future. And instead of making a donation of 100 to 250,000, which is what it could cost, you can donate a life insurance policy, which would fund that now, which would fund that in the future once you're gone, at a much more reasonable price. And because the nonprofit owns the policy, it's a donation to fund that life insurance policy. So that also is tax deductible. And happy to go into questions after this. There are many different solutions, as both Gilfix has mentioned, to Prop 19. This is one, especially if you have an only child who has special needs that will require either in-home supportive services, or you want them to have roommates in the future. So you get, and there is a lot of real benefits to parents. One is, of course, you get that immediate tax deduction on your house while you're alive by putting it into a trust structure. And there's benefits over multiple years against any income that you have. And then also it reduces your property tax burden. You'll have to work with your individual special needs planning lawyer, and we have some property lawyers we work with. But it's a beautiful way for you to benefit someone like a AbilityPath and create housing in the future for other special needs individuals who may not have housing, while also having benefits to tax benefits. So really what we do is, help create additional housing supply by putting compatible individuals into these homes, and and make it much more, especially for people on a fixed income. This is a way for you to plan as well to continue to live in the home by leasing it back from the nonprofit, and the nonprofit technically will be the one that owns it. And we work with you on what support services that you will require with your estate planning attorney for your child when you're gone. So, as Mark said, hope is not a strategy. And so this is really a way for you to think about, especially if you have a only child, to ensure that they have housing in the future, since there's such a wait list in California, while also making sure that organizations like AbilityPath are able to provide housing to loved ones. So the donation process is relatively straightforward. Housing is never a straightforward donation. It's a big consideration, but especially with Prop 19, as Mark and Mike mentioned, this is one path forward to mitigate that step-up basis in property taxes that is a real issue in California. So the donation process is, happy to have a free consultation with you and work with whatever nonprofit you care about. Of course, we're here in the AbilityPath Conference Center, so I'm sure they'd be open to a conversation. And we'll work with you and your estate planning professional to see if it's a right fit for you. And then coming up with the documents that are required to make sure that it is transferred properly in dealing with your mortgage, et cetera, in different structures. So we're here to support you from the legal side, and as best as we can, working with your attorney, and we have some attorneys as well. So happy to have a consultation with any one of you, or if there's other families that you know of that this would be a good option for them. There's a lot of tax benefits to the family now and in the future. Some, the aspects, one of the questions that I get asked from time to time is, can you guarantee my child will live in that house forever? And of course, as a child needs step up in care, that's something to consider when you are donating a house where your child is the primary resident. Of course, your child, if they need step up in care, putting in those frameworks so that you as the parent and the nonprofit can have that conversation now, so you can plan to know what will happen to my child should they need step up in care or other services that may not be capable of being provided in the home. So those are things to think about. So we're happy to have a conversation, and bring in some of the right individuals. But feel free to reach out to me. My email is lev@cradle2.com. And we can also help with funding the maintenance, the house maintenance in the future, and/or in-home supportive services, supplemental and home supportive services through a life insurance structure. Well, I guess I know we're coming up to the end here, so happy to answer questions. But again, lev@cradle2.com. And I think that's it. Thank you.
Thank you. So we're going to take questions now. So I'm going to bring the chairs up. If Jim is Mark and Mike, let's see, and Lev, please stay up here and we'll get the microphone and ask questions. Our double duty, we're stagehands.
Thank you.
Next up, Mark, so we can trade off.
Letting the gill fix it.
Sure. I'm going to be standing.
I had enough.
I will stand. All right. Thank you again, gentlemen, for the informative session. Appreciate it. Also for the generous offer of free assessments and consulting help for anyone that wants to reach out to them. And I need my glasses to be able to read the questions. All right. How does SDP fit into all of this? Self-determination program, how would that fit into? And Jim, this may be for you a little bit. How does the SDP program fit into all of this?
Yeah, SDP is the self-determination program that is now in place at all regional centers and is available to all consumers and their families of regional centers. I'm trying to think of how it fits in with what we've been talking about, but let me just describe what self-determination is. The traditional way of services being provided by regional centers is by regional centers funding the services through vendors. Those are individual entities that have agreed to accept the state rate that is paid to them for services, whether it's independent living skills or supported living or tailored day service or adult day programs. But many times what we're finding, as you can probably imagine, is that the rates that are paid to those vendors is many times not sufficient to attract qualified staff. So one of the things that self-determination can do is it allows services to be purchased from non-vendors. It can be purchased from vendors also, but it can be purchased from non-vendors at a higher rate. Now, you have a fixed budget The budget is determined by how much the regional center has spent on that consumer the past 12 months, plus what it would cost the regional center to provide services for any unmet or new needs. So that becomes the budget. So when I work with families, we goose up that budget as much as we can. We think of every possible thing that this consumer could need. That creates the budget. Then we move to the spending plan, and that's how the money's going to be spent. But it doesn't take an economist to figure out that if you spend money on all the things that on how you develop the budget, it's not going to help you. You're going to end up paying the same rates. So you have to steal from Peter to pay Paul. So in other words, you don't provide some of those services that you identified as a need so that you've got the money to pay for some very focused services at a higher rate. So that's what self-determination. Now, the money's not given to the parents. It's given to what's called an FMS, a financial management services entity that actually receives the money from the regional center and disperses the money to the people the entities that are providing the service. So self-determination works great for some families, and usually is for families that have identified a provider that they want to use that's not a vendor, but they want to use it. They want to use John down the street who's going to teach landscaping skills to my son, but he's not vendored. But you can use John through the self-determination program and hire him to help teach those skills. So it's worked well for some families it doesn't work so well. Some have gotten into it, some have gotten out of it, which you can do. You can try it out. Doesn't work for you, you can go back to traditional.
Great, thank you. Mike and Mark, a question for you. If the house belongs to a trust, does Proposition 19 apply?
Real typical situation. So there's two trusts. There could be your living trust, your revocable trust, and if the property passes out of the trust to your child, to a special needs trust, there will be a reassessment. So going into a special needs trust does not protect it from that because it's a change in title. If it's in the special needs trust and then it passes to someone else upon the death of your child, the beneficiary, again, that's a change in title. That's another reassessment. So it just keeps going up and up and up without protective planning.
Okay, a follow-up question to that. Do you need to have a special needs trust set up while you're alive, or can you give directions to open one in your living trust?
Good question. We occasionally see plans that say, when I pass away, a special needs trust will be created or will be formed. We are big believers that that's not the right approach. You should set up the special needs trust now. One, that means you have control over its terms. You can set it up the right way. You can update it. And two, if you're doing that, the special needs trust doesn't exist yet. There are many situations where you might put money in the special needs trust while you're still living, or if any other relatives or other people in your family might want to help out your loved one, they need to direct money to the special needs trust. If it doesn't exist yet, you can't name it as a beneficiary. If you want to coordinate life insurance or investments to flow to the special needs trust, well, what are you going to tell the life insurance company? It's going to go to this trust that doesn't exist yet, that might exist in the future if everybody does everything right. So many reasons why we'd say set up that special needs trust now as a separate entity. It should not be embedded in your living trust. It shouldn't be created later. Create it now. You can update it, but create it now.
Great, thank you. Lev, this one's for you. What is the typical profile for those who would benefit most from a legacy housing plan?
Well, I think the typical profile is somebody with the only child that wants to make sure their only child is taken care of, and also has is interested in having them have compatible roommates. That is usually the best scenario. It depends on what their special need is. Every special need is unique. So it really depends on what their plan is. Are they able to live in a home by themselves, hopefully for a long period of time, and have a compatible housing situation?
Great. And the question here is there a list of questions to answer for those of us wondering about a legacy home plan? Do you have FAQ, anything that we can put up on the website?
Yeah, we can put things up on the website. There's handouts on the table.
Okay.
There's so that can answer more about that. I think the key thing to consider is, you know, what is a good partner organization for me? And, you know, that usually they have a long track record of providing services or housing. And then, of course, the parent can continue to live in the house through a basically donation and leaseback model, depending, you know, and thinking really it's having to come up with a budget for what is the maintenance on the home now and in the future.
Great. And just as a reminder, we will send an email to everybody when the video of the session is completed, so you have access to that. And we will transcribe that, which will include all of the questions that were asked here today. Next question is, do you pay taxes on the trust?
So you're talking about, we'll say it's a special needs trust who
Correct.
pays taxes. So
Yep.
trusts pay income taxes just like individuals do. So the trust, let's say $1 million goes into a special needs trust. There's no tax on that $1 million unless it's a massive estate and it's over the estate tax limit. It's income generated by the trust. So let's say the trust invests that money in stocks and mutual funds, things like that, and or owns a rental property, and it generates, you know, $50,000 a year in income. The trust has to file a tax return and has to pay income tax on that. There's some nuance there because if the money is used to support the beneficiary, that might be income attributable to the beneficiary, which might be a lower tax rate. There's some strategies there, but the bottom line is the trust is responsible for income tax generated.
There's two people had asked, what's a typical fee for a fiduciary or a trustee?
That's a very good question. We get that question all the time. So yes, trustee, fiduciary, professional, or family member. So whoever is serving as a trustee of a special needs trust, it's a big job. It's a big responsibility. There's liability, there's risk. It takes time. So anyone serving, we typically draft our trust to say reasonable compensation, and that's on purpose. We don't want to necessarily spell it out. Professionals, there's two ways they charge. Either they charge an hourly wage where they just keep track of time and pay themselves an hourly rate. I was actually at a fiduciaries conference a couple of weeks ago. I see rates from $150 an hour to $350 an hour, depending on their level of experience and expertise. Or they'll typically charge on an annual flat fee basis based on the size of the trust. So for larger trusts, they might say, well, that's a bigger risk for me. There's more liability. They'll charge maybe 1% per year. It's a sliding scale of the assets in the trust when they're managing it. So it's usually, we're seeing more and more fiduciaries and professionals, and certainly banks usually charge that percentage flat fee every year, but some do hourly. And family members, though, can also pay themselves. Usually that would be an hourly wage where they keep track of time, and we encourage them to pay themselves because you want them to be incentivized to spend time doing it right. So it's a wide range.
Great, thank you. Jim, I think this was for you. It's leaseback means cash flow. So what is the cash flow impact of a leaseback structure that I think you'd mentioned?
I'm not sure that's for me.
Was that you? Was it the Gil Fixes? I couldn't remember where that came from.
So yeah, a leaseback structure is a pretty common term in real estate. It's really where you are no longer the owner of the residence, the owner becomes the nonprofit. And that's really where, because special needs nonprofits have what's called the welfare property tax exemption, most of them, they don't pay property tax. And so basically, instead of you being the owner of the residence and paying property tax, you effectively rent it for a specified period of time, usually until the primary resident passes. You're renting it back from the nonprofit, and you still continue to live in the residence. So that's what the leaseback means, is you're going from being the owner of it and maintaining it and all those things to being a renter effectively in the home.
Great. And Jim, this one is for you. So my child is a GGRC client, Golden Gate Regional Center client. How does that affect SSDI CDB eligibility?
Doesn't affect it at all.
Right. That was fast. I didn't expect that to go so quickly. All right. A special needs trust, are they governed by federal or state law? Which one, or both?
They're fundamentally a creature of federal law. There's guidelines saying that they work. Many states do have their own guidelines. California really doesn't have anything to speak of because, again, it's federal government benefits that the trust is sensitive to, being sure that it doesn't interfere with eligibility for SSI, for any government program.
Okay, great. Jim, you may have information on this. The question is, what is the cost of group home residency? Is it similar to assisted living? And what is the typical inflation rate for the fees? There's a lot there.
Yeah, I would only, is the question, what does the regional center pay? Because group homes are usually paid by a combination of the individual's benefits through
Yeah,
Social
I think
Security.
maybe knowing how complex it is for what's paid for, rent versus services and all that, maybe give a quick outline of kind of somebody's living in a group home, where do their funds come from to allow
Okay.
them to live there?
If an individual is a regional center consumer, the group home is paid for by the combination of the individual's SSI or SSDI, CDB, and then the regional center picks up the balance.
Okay.
So, and that can be quite expensive. So it's when I ran a regional center, that was one of the biggest ticket items we had was for group homes.
So maybe, given that the individual's needs determine the reimbursement rate from the regional center and, homes from a level 1, 2, 3, 4, kind of just an outline of what that means for somebody looking for a group home and a licensed facility for their child's care.
You mean what the cost would be?
Roughly just the type of service and that would be provided by the regional center, paid for, reimbursed by the regional center for the service at the home.
Group homes, as you said, are determined, they're licensed through what's called community care licensing. And the regional center places consumers into levels 2, 3s, and 4s. And then also it goes across the other way, all the way up to a 4I. 4I is the highest level home that regional centers place into. And those are behavioral homes. And that can run about $9,000 a month. And so the regional center, and as the level of the home goes up, the requirement for the group home to have additional staffing, to possibly have a behavioral consultant on staff. So there's more requirements of the group home as you get higher. And the level of the group home is determined by the regional center when they assess what the consumer's needs are.
Yeah. And I will say that depending on the regional center you're in, you can always reach out to a social worker to talk about your child's plan and what the reimbursement might be and what the services for the particular home they'd recommend. And they do provide
Brian,
referrals.
I want to jump in for a moment. One point that I think has to be made, and it's one of the many elephants in the room, is when we talk about levels of reimbursement and what the regional center can pay and what the level of SSI is and all of these numbers, we have to be aware that there are serious threats to the funding sources at the federal level. So
Today,
I mean, there's not enough
right
money
now,
now
right.
for regional centers. So we're very worried about what's going to happen in the future, what's going to happen with the federal Medicaid program, which is Medi-Cal, which is IHSS. So, as voters, you should be reaching out to members of Congress. This cuts across everything. It goes to the ability of a family to maintain a house. It just cuts across everything. It is, in a way, it's a direct affirmation of this idea of taking care of your child, maybe with everything you have, and that could be the home being set aside for your child in a safe way. We just can't ignore that. Not everybody has a home to set aside for the child. You might have 5 kids. So, it's a really heavy duty comment. And it just cuts across absolutely everything.
Yeah. Thank you for mentioning that. This is a little bit, I think for Jim, for you. My daughter is diagnosed with renal failure under dialysis, happened after the age of 22. Can she get benefits from Social Security under her parents' SSA program? And the second part is, can she get SSI as well?
She can, as I said before, until a parent goes on Social Security retirement or disability, we would apply for SSI. And then once one of the parents goes on to Social Security retirement or disability, then we would shift over from SSI to SSDI CDB. However, I have some clients that get both, because let's say the parents paid into the PERS system or the STIRS system, and maybe the other parent paid a little bit into Social Security. The amount of the monthly benefit may be only $300 or $400. If that's the case, the individual, the adult, may also qualify for an SSI check. So they would get 2 checks.
Okay, great. Thank you. So that's the questions I had. Does anybody want to raise their hand with any other questions that we may have missed? Yes, sir.
How about the 50-50 split between the children.
So you had mentioned that, and I'll be honest with you, I didn't know how to phrase the
Sure.
question, so I'm glad you
I
answered.
understand.
I think it really needs.
50-50. I mean, you have two children, one normal, one with disability. Of course, when we pass, 50% goes to the disabled child in her special trust. How is it going to work out? Although we have our own revocable trust, which is stipulated right there, 50 goes to the normal, 50 goes to the disabled.
Right. So the question goes to the planning you do for your family if you have more than one child. And in the hypothetical, you have two kids. What about this idea of 50-50? Each kid gets half. How does that fit with the house being set aside for the kid? The most important point is that nowhere is it written that it has to be 50-50. So in countless situations, special needs in particular, one child, the one with the disability, may get 60%, 80%. I have seen 100% set aside for the child with a disability. And when you look at the house, which is usually for most people, that's the bulk of the estate. So again, if you want that house to be there for your child, if you do the program that Lev was talking about, or you simply have that house go into the special needs trust for your child, it's not going to be 50-50, right? But in the special needs trust, you might say when that child dies, it goes to his sister. So ultimately you work it out. But again, I have never believed, and I'm not the majority view, I don't think, that it should automatically be equal shares to each kid. You look at their needs, you look at their capacity, you look at their life circumstances. It's our values in a way that I think should control us as we think about this, not automatic thinking. So be creative, think about the needs of the family, act accordingly.
Thank you for that question. Yes, a follow-up?
Yes, that was in my index question for Jim for the SSI and SDI
CDB, very good.
Will you qualify for that? I mean, will our child be able to qualify for SSI and SSD?
Well, again, under both the programs, the applicant has to be considered disabled. And that means that they're not capable of substantial gainful activity. On the SSI, there's also the financial requirements I talked about. Less than $2,000 limited income. SSDI-CDB requires that the parent be on Social Security disability or retirement. Okay, so that's the requirements for the two.
What if Social Security already declined the application for SSI, I mean the SSDI, the second part anyway?
SSDIC.
The child is not disabled, but the child has been on disability for quite some time.
When you say on disability, you mean they've been getting SSI?
Yes.
Then they may not qualify for SSDI-CDB if they've worked since they were 22.
No, how do we reapply? How do we make that appeal?
Oh,
if Social Security?
how do you apply for the benefit?
I'm sorry.
How do you feel with denial?
Oh,
Do we need an?
are you asking if the application is denied, how do you appeal it? Yeah, with many of the families I work with, for a variety of reasons, they get a denial letter. And one of the first things we look at on the denial letter is the last page will list all of what's called the sources that that Social Security sent for the records of that individual. Because Social Security has to receive the records that show the person has a disability and that disability precludes them from working substantially. Well, what happens is Social Security doesn't get all those records for a variety of reasons. Dr. So-and-so maybe didn't respond, or the school district, has destroyed the records after 7 years. So what we do is the first thing we do is we look at all those sources that the parents gave to Social Security where Social Security could send for records and see if records were not received. Now, if those records can be obtained somehow, sometimes the parents will dig a little bit deeper into their files. They'll find an IEP from years ago. School doesn't have it, but they have it. So we would file the first level of appeal is called a request for reconsideration. But if we don't have anything new to send to Social Security when we're appealing it, they're going to deny it again. So when we file that first level of appeal called a request for reconsideration, we have to provide either new sources, new places where Social Security can send for records or actually provide the records.
Will you be able to help us out with that?
Certainly. I do it every day.
All right. Yes, sir.
How you doing? My question, I got here a little late for work, but you have under needs-based benefits, SSI, Medi-Cal, and IHSS.
Got it.
And you're saying that after 22, they need to, I thought I heard you say they need to move over after 22?
When you say move over, you mean from SSI to SSDI CDB?
Yes.
Well, you would want to do that. I had mentioned that it may well result in a higher monthly cash benefit to the recipient if they if they apply for SSDI CDB after having been on SSI. But the after 22, that when I reference the 22 is if they have worked since they were 22, they're not going to be eligible for the SSDI CDB. They may still remain eligible for SSI because SSI looks at whether you're disabled right now.
Okay. All right, do that.
Hey, Jim, are you creating a chat bot that can answer all these questions for, this is really complicated.
Yeah, I know.
All right. That was my humor for the afternoon. There you go, dad joke.
Thank you, AbilityPath and all the expert panels. So 2 questions. One is, what is determining a child is a special needs trust candidate? Is it that they have IEP or that they needed the developmental pediatrician?
Yeah, very good question. So like a broader issue is there a requirement for me to create a special needs trust for my child? And there is no requirements at all. So the special needs trust, we had talked to a lot of families, especially in the autism community where their child is on the spectrum, but they're very capable. And as we know, a lot of Silicon Valley leaders are probably on the spectrum. And so maybe they'll be, you know, a genius CEO, or maybe they won't be able to work. There's absolutely no requirement that your child have a disability for you to create a trust for them. What that impacts is how the trust is managed for them. And so we generally say, hey, when in doubt, create a special needs trust, because if they have a disability and can't work, well, they retain government benefits eligibility, as we've talked about. But if they can work and they're doing fine and they don't need government benefits, then you just have a third-party trustee overseeing money for them, just as any trustee would oversee money for anybody. And if the trustee thinks they really don't need it, the trustee could usually have the power to just give them the money outright. So when in doubt, we say create that special needs trust. There is no requirement that the child have any disability.
Then the follow-up. So I remember when we first started, they told us, okay, don't put any money in, don't do the scholar share because you don't want over $2,000 and anything under her name. So currently she's an only child. She's also the only grandchild. So both my mom in New York, you know, my mother-in-law in Oregon, so they all have living trust, our parents. They always want to give her money. Chinese people like to, for red envelope, but I always say hold off.
Yeah.
Because I don't understand, I don't want future ramifications of negativity because of the income situation. So I should set up the special needs trust, then they will gift into that because they're from, you know, the trusts are from New York, from Oregon.
Yeah, so that actually, so 2 issues here to talk about, like should grandparents or parents give money directly to a grandchild that cause issues, or what are other ways to do it? And out of state people, I think there's an implicit question there. Can they leave money to my special needs trust? And
we live here.
yeah, if you're living here. So so that second part, your special needs trust can get money from anyone in the country. They don't have to set up separate special needs trusts. It's very common for multiple family members to give money to the trust. And if they really want to give money to your child, yeah, I would definitely say to the special needs trust. I'm not sure how that would impact scholarship issues because special needs trusts are really designed for more general government benefits. So I couldn't say for certain. There may be a clear answer. I think it would be fine. I think it would not interfere with government scholarships. So yes, it would go to the special needs trust then. And just to that other question of why not put money into special needs trust ahead of time? Well, if it's just a little bit of money, once you put money in the trust, it has to file annual tax returns. There's some reporting requirements. So we usually say if it's not that much money, if it's a couple $1,000s, probably not worth putting in the special needs trust. But if they really want it to be there for your child, then maybe that is the right choice. Something we'd always talk about. Oh, down the road, yes, it all should be directed to the special needs trust. Oh.
I'm just wondering, in that scenario, would a CalAble account be the way to go? Like families giving $1,000 here or there, gift to a CalAble?
Yeah, CalAble would work on that, but let's go back to the situation where there's one child, and that's not uncommon at all. And if you think about the planning that you're doing, you're setting up a special needs trust for your child who has a disability or your grandchild who has a disability who can't work. So the question I ask you to think about when you're doing that is what happens when your child passes away? Who's going to get the money? So, I mean, from day one, I mean, for like 35 or so years, we've always said that's a time to think about nonprofit organizations. And it's not just because we're here, it really is. And we've said this consistently forever. What are the organizations that have been key to the quality of life for your child? What organizations are struggling? I don't have to sell you on that. You understand. But think about who's going to inherit. It goes to this 50-50 thing. Nowhere is it written that your family members have to inherit or anybody. It's up to you to decide where that money is ultimately going to go. And I think that's kind of the perfect scenario for identifying your favorite nonprofits as ultimate beneficiaries, or at least for a significant portion of the estate.
Yes, just 1 second. Anybody remember Phil Donahue running around? Here we go.
So my question is regarding the not working after 22.
Oh, okay.
How much work is not working, right? Because let's say my child, I don't think he could support himself working in the sense like I think he could get a job, he cannot maintain a job, right? And so he will have to get jobs that are specifically designed for people like him. But I would love for him to still have a routine of going to work, responsibilities and all that. So how does it work like to have, like, where is the balance and
Yeah, good
where
question.
is the line of has not worked?
Yeah, even though the person is not making 1620, let's say they're making 1,000 a month. And again, remember, if they're on SSI or SSDI, you have to report that income. They're making 1,000 a month. That could trigger what's called a financial review. It could trigger a review. And Social Security can say, well, even though your adult child's only doing 1,000 a month, he's really capable of 1620. He's just artificially holding it down. So you run the risk as the monthly income increases. I tell my clients, if you want your cake and eat it too, if you want to remain on your benefit and you want to work a little, stay off the radar scope of Social Security, only earn about $300 or $400 a month. It's not a guarantee, but it doesn't raise a whole lot of red flags. If you start getting up to 1,000 or 1,100 or 1,200, they could say you're capable of 1620. You're just artificially holding down your earnings to keep your benefits.
Like the variability over the course of many years, right? After 22, we see when our child's only 15, but like all of a sudden he has horrendous behavior, and then all of a sudden he goes to a space where he can do more at school, and we can see that happening.
Well, unfortunately, that
Medication work, no, the medication doesn't work anymore.
right. Well,
So how is it?
unfortunately, it's hard and fast that if your child has shown that they're capable of substantial gainful activity or achieved substantial gainful activity since they were 22, anytime they're not capable, then they're not eligible for SSDI CDB. And we would have to go to SSI. In other words, right now, they're not capable of working.
Then once they qualify for that, once they qualify, let's say, we're older parents, so by the time we qualify, it's not too far. Less than 7 years away from it, he's gonna be just barely coming out of high school. If you apply at that time, then it stays that way, or it keeps being checked over the course of his life.
Well, it would be checked because you're turning in the pay stubs every month. That's how they keep track, or you should be turning in the pay stubs. Yeah.
And the limit is a total of 9 months across the lifespan.
Well, they look, now you're talking about SSDI CDB where it triggers that trial work period. You continue to get the benefit during that time, but the threshold there is about 1160. If you show that you can earn 1160 during that 9-month period in a 5-year window, then your benefit will be terminated because they'll consider that you're capable of the substantial gainful activity. So you have to be really careful of trial work periods.
My two final question,
Let
I'm
me-
sorry.
I want to
okay.
just comment on that really quickly. Okay, so I mentioned a moment ago about what's happening at the federal level, which directly affects everybody in the room. You have to be we work hard to watch everything in this realm. Okay, the other thing that's going on, it isn't just cutting back benefits. There's a lot of discussion about stricter work requirements. They're focusing on the deadbeats. You know, they have this vision of these legions of deadbeat people who could work but don't. But if they change the rules to tighten things up, it's going to affect everybody. And I think it'll result in more scrutiny on this issue. The bar will be lowered to pull benefits. So again, it's being aware of what's going on, be advocates for your community. All these things tie together.
On that, what Mike just mentioned, we are keeping close tabs on what's happening at the federal level. And as was mentioned earlier, whatever happens there trickles to California, and it impacts San Mateo County as well. So this is the tsunami that builds up comes down to local services. And we are keeping an eye on it. We have been working with multiple statewide advocacy groups to be able to marshal resources and amplify voices to raise the dire impact that any cuts to Medicaid and services, social services would have.
Is it a good time to fund the trust right now? And is there a tax implication, right, if we fund it? And second question, and my final question, we created the conservatorship, and what we didn't realize, we have to pay the court for every investigation they do. Is that something that in a fine print, that's $800 for a conservatorship every year?
Well, so for the first question, should I put money in the special need? If you have a special needs trust, should I put money in it now? And I would say, absent some other specific circumstances, talking with us or another expert, I would say no, generally speaking, as long as, because basically a special needs trust, we often see it as when mom and dad step out or can no longer be there, the special needs trust steps in. So as long as you guys are there, you can basically function as a special needs trust will later. You can pay for your child's expenses. You can do so in a way that shouldn't interfere with public benefits. It's kind of the same treatment, whether it's coming from a special needs trust or a loved one helping to pay for things. It's not such a big difference. And once you have money in the trust, one, you have annual filings. You have to file tax returns. And two, if the trust has more than a certain amount of money, trusts actually get taxed at an accelerated income tax rate. So once it's making more than like $25,000 or $30,000 a year in income, it actually pays a higher income tax rate than most individuals do. And it also then makes it harder to change the trust down the road. So generally speaking, we'd say, don't put money in the trust now, absent some other reasons. That's the presumptive issue. For conservative.
Would that be a good thing?
Yeah, getting an EIN. We usually say don't. So to fund a special needs trust, that's a good special needs trust 101. People think like, how does this get set up? It's as simple as we usually on behalf of our clients get an EIN, a tax ID number. It's like a social security for the trust, social security number. You give that plus a copy of the trust to a bank, to Schwab or whatever, then you can open accounts. So usually we'd say you don't need to get that EIN until you're about to fund it. Because again, once you set that up, that EIN, you're on the IRS's radar, and it means you have annual filings that are not super hard, but it's just kind of an annoyance. So why not wait until you absolutely need it? For conservatorships, I mean, the fees are what they are. We often try to help families to avoid conservatorships when we can. A lot of the times people come to us and say, I need a conservatorship. My child's turning 18. And we'll say, hey, wait a second. Maybe instead of a conservatorship, that child, if they have capacity, they can create their own power of attorney and advance directive to voluntarily give you the ability to step in and help them out. So we often, when we can, we try to avoid them because of issues like that. They're costly. There's a lot of ongoing reporting to the courts. So sometimes you need them. So as far as the fees, they are what they are.
Disability that came in as a conservatorship due to that disability. It's not physical disability.
Yeah.
It's a mental disability.
Yeah, and we work with clients with all types of issues, and whether it's a mental illness or a physical disability, that doesn't preclude someone over 18 from voluntarily creating their own power of attorney, saying, hey, mom and dad, I am voluntarily letting you help me and step in for these things. But sometimes a conservatorship is needed if they're not, cooperating or if they don't have capacity.
All right. One last question? Yes, sir.
In full disclosure, we do have a special needs trust, but our attorney retired, so I do have a, I have to revise it. So there's this notion of a regular trustee and an independent trustee within a special needs trust. Is that possible? At least ours has it. That monitors the disbursements to make sure it follows the health, education, maintenance, and support requirements.
Yeah. So I think I think you should weigh in after this, Mike. So you're talking about like in a special needs trust, is there a place for sort of two key decision makers? So
Trustees who manage the assets and the independent trustee who makes sure that the disbursements are HEMS, health, education, maintenance. And support.
yeah, so like having a check and a balance sort of
Yeah.
trustee to oversee the trustee. So usually we would say we're not big believers in having sort of a secondary role. Either you would have one trustee who you think will handle it all because the trustee is the trustee. If you have someone else checking on them, why aren't they just the trustee? Or you
They're
can name them
complications.
as co-trustees potentially together. Or what you're talking about is like a role of maybe a trust protector, someone who sort of oversees what the trustee is doing with the power to replace them. So those are different options. We're big believers in keeping things as simple and as elegant as we can.
Yes.
And the trustee's job is to use trust funds to pay for, gym services or our services to get that guidance. They have a fiduciary duty to uphold that. So, that's certainly an option, but we don't find those to be very efficient. It adds cost to the trusts. So that would go to your choice of trustee up front. There's different options for that, though.
Okay, clearly it's complicated enough that I don't understand it. So, which is why it needs to be revised. The thing is,
Give us this whole set of meeting.
the thing is, who monitors whether the trust is being administered carefully and properly and within the law and so on, right?
That's
Who
a
monitors it?
great question. Who monitors the trust to make sure it's being handled properly? The trustee is not taking something. That's very challenging. So the beneficiary, if they have the mental capacity to do it, they have a right to annual accountings, and they can always take the trustee to court and say, "Hey, you're not managing this well." Otherwise, it would have to be someone in the family or someone watching over. I mean, it's a challenge. Trusts are private documents,
Mark,
and
is
if it's
there
not
maybe
court,
maybe a little bit, again, trying to keep things simple. When the trust tax return is done, is having the accountant use an outside firm to do the accounting, just to take a look
Yeah.
at that?
yeah. Mike, thoughts? Yeah.
Well, okay, so there's the finances of the trust, and a
that's maybe
CPA
what his
could look
question-
at
yeah.
that and say, was everything done by the book, et cetera, which I don't think is the issue. I think
Right.
the issue is quality. Is the money being used appropriately for the well-being of the child? And again, that's where, many attorneys are fans of the trust protector. It's a second person who gets a role. They're identified in the trust. A lot of attorneys use those automatically. We don't. It depends on the circumstances. If for whatever reason, the person you've chosen is utterly trustworthy and you believe in them, and my hope is you wouldn't name them unless you had that, you're not as worried about it. A lesser approach, and we do use trust protectors sometimes. Again, they're given, among other things, they're given the authority to replace the trustee. And you don't have to. The trust protector does what you let them do. You define in the trust what roles they have. So that means they have to get accountings, they have to have reports, and it raises a cost issue. If the trust protector is going to get the information needed, the trust has to pay the trust protector. Who controls the purse string for the trust? The trustee. So the trustee is paying the trust protector to watch the trustee. So it builds in a dynamic that is okay, But, from day one, when I saw the trust protector emerge as the way to go, I was a skeptic. So I don't think mine is the majority view, I got to tell you. But I think there's other ways. You can also do accountings to other individuals in the family. You can also build in a mandate that a social worker with skills, somebody who might have worked at the regional center, does an annual or every 6 months does a review, and they do a report to the trustee and maybe to someone else in the family. So again, I think it's very case specific. Who's named, how much do you trust them? If it's a professional, it's a different approach entirely. That's where you might name a family member as the trust protector. So again, there just isn't one way.
Great. So join me in thanking we have one more question? Okay, I'm getting okay, here comes the microphone. One last. You're gonna be our closer today.
Thank you. I just wanted to ask, when would be a good time to fund that trust? Because we form it now, right? And you said, don't fund it until such point as it's needed? Is it upon our death?
Yeah.
Do we build that into our estate planning?
Yeah. So Plan A, the presumptive plan, is you have your trust. They're your assets to take care of you. You use that money as you please. You use it for your child as you see fit. So you're taking care of yourselves first. You're the primary beneficiaries of your trust. And then it's upon your passing that the money would go into that trust. But again, there are many circumstances when folks do, not many, there's some circumstances when it does make sense. Sometimes it's an asset protection thing. We have some folks who are very worried about being sued and they want to put money in somebody else's category so the money can't be reached. Not common, but it comes up. There can be tax reasons. This is not about estate tax today, but the level of estate tax, death tax, sometimes it's called, is so high right now, hardly anybody has to worry about it. But it wasn't that long ago when the limit was $1 million. Everything over 1 million was taxed. So the point is, there's a number of tax reasons. There's a number of tax reasons why sometimes you would do that. And we could come up with other circumstances. Strong presumption. Mark mentioned why not to fund it unless there's some discernible need.
All right. So join me in thanking Mike, Jim, Lev, and Mark. Thank you so much. And before we go, I want to thank the AbilityPath team. Where's Kirsten, who helped put together today's event? Kim, Sarah, and Greg.